Chairman, ranking members, members of the committee, thank you for the opportunity to speak with you today. My name is Sylvia. I'm a partner with Phillips and Cohen, which specializes in representing whistleblowers under the federal and state False Claims Acts. Much of the discussion today has been about auditing and oversight, and as important as those efforts are, even if they worked perfectly, and they don't always work perfectly, there would still be waste, fraud, and abuse. As many have acknowledged, that's sort of inevitable. And I'd like to talk about a different way of addressing waste, fraud, and abuse, more on it, also a preventive method. The government's most important tool in fighting fraud against the government is the Federal False Claims Act with its qui tam whistleblower provisions, which provide incentives to private citizens to pursue lawsuits on behalf of the federal government to redress fraud. The Act, first enacted in 1863, was substantially amended 25 years ago when Senators Charles Grassley and Representative Howard Berman led successful efforts to amend it and to provide additional incentives for whistleblowers. The changes Congress made in 1986, which provided whistleblowers the opportunity to play an ongoing role in the cases that they initiate and enhance the resources of the federal government in pursuing these cases, have proven phenomenally successful in addressing fraud, including Medicaid fraud. The Department of Justice reported that more than $30 billion has been recovered under the False Claims Act since 1986. The reason the Act is so successful, and the state acts are also successful, is that they address two key problems in addressing fraud that are a problem for the government. And the first is the lack of information. No matter how much auditing you do, what whistleblowers provide that the government doesn't have is information about fraud. As Congress recognized when first enacting the False Claims Act and again amending it in 1986, it's very difficult to detect fraud without the cooperation of close observers of the activity. The False Claims Act provides incentives to persons with knowledge of the fraud to report that information to the government. Those incentives include not only the possibility of a reward, but the opportunity to have an ongoing role in the case, as well as protections against retaliation. Without those incentives, few individuals would be willing to risk the cost to their careers of the type that we've heard about today. Other oversight methods, such as data mining and audit programs, can also serve an important role in detecting fraud, but the ability to harness the information of insiders has proven especially effective. The False Claims Act qui tam provisions also address another important problem that the government has in fighting fraud, and that's resources. The government will never have enough resources to pursue fraud. As government recognized in 1986, large corporations that are the subject of fraud investigations are often able to devote significant resources to these cases and often outmatch the government. The False Claims Act addresses that problem by providing incentives to whistleblowers and their lawyers to assist the government. Cases under the False Claims Act can take a very long time, many years to develop and pursue, and typically require tremendous investment of legal resources. The combined efforts of the federal government and private resources have been uniquely effective in pursuing fraud. The recent changes in federal law will actually assist further in addressing Medicaid fraud. Congress amended the False Claims Act in 2009 to clarify a number of provisions of the Act that were inconsistent with Congress's original intent. The Affordable Care Act provided additional tools, and importantly, the Deficit Reduction Act in 2006 provided incentives to states to adopt their own False Claims Act acts, and a number have done so. And together with the federal government, they've been very effective in pursuing Medicaid fraud. The success of these provisions in addressing Medicaid fraud is undeniable. According to the Department of Justice, in the fiscal year ending 2011, recoveries under the False Claims Act reached a record $3 billion, and the year before also was close to $3 billion. Of that amount, $2.8 billion in recoveries was attributable to claims brought under the whistleblower provisions of the False Claims Act, and $2.4 billion of that amount involved fraud against federal health care programs, including Medicaid. Medicaid fraud takes a variety of forms, and we've heard about a few of them today. They can be as simple as a single provider addressing Medicaid fraud, but they can also be incredibly complex. They can include things like unlawful pricing schemes, off-label marketing, and other types of complicated frauds. And all of those take resources beyond those that the states have to address them. Not to be lost in all of this is the deterrence value that these suits can have on preventing future fraud. So in summary, this is a bipartisan effort fighting fraud. Everyone wants to make sure that the money is spent on the people it was intended to help, and the False Claims Act is one way to do that.